Constituency Affairs. Parties are absent, my lord.
Appearances. Appearances.
Announce the appearance.
Appearances.
With utmost respect to my noble lord, I am H.A. Obito. Humbly, my lord, I appear for the claimant.
Profound respect to this honorable court.
Any other appearance?
With profound respect to this honorable court. I'm O.W. Obaido. My appearance is for the second defendant.
There's no appearance for the first defendant. No appearance for the first.
None, my lord.
Very well. Here's the judgment of the court.
As the court please.
Please, you can mute your system. You can mute yourself so you can hear me.
As the court please.
It is a claimant case that their councillors in Lokoja local government during the 2013 to 2016 office holders, they are entitled to certain remuneration officers amendment law number 1, 2006. Aside from this law, the revenue mobilization, allocation, and fund benefit of political office holders, which equally affected them. The Kogi State House of Assembly had passed resolution on the issue of remuneration or allowances of claimant Kogi State. By several instruments, they are entitled to salaries, severance allowances, and furniture allowance, which they are to be paid by a resolution of the court to be paid the statutory salaries, severance, and furniture allowances for the period of 3 years they were in office. However, they were not paid their salary for 10 months, January 2015 to October 2015, pursuant to a judgment of the High Court, in suit number KG KKCB 002 2013, 8 of December 2014. But that the judgment was set aside by the 3rd of October 2015, and by which judgment they are entitled to be paid for those 10 months. Defendants were initially indebted to them in salaries, severance, and furniture allowances in the sum of 75,851,384 naira, out of which the sum of 3,821,172 naira 20 kobo was paid, leaving a balance of 72,030,211 naira 80 kobo. That all these entitlements have been provided for under the remuneration of certain public political office holders law. That there was an upward review of salaries of councillors by virtue of the 2009 recommendation of the Revenue Mobilization, Allocation, and Fiscal Commission, and which puts their entitlement for those 3 years at 50,543,700 naira, and that they have equally made repeated demands for it to be paid for to no avail. They have caused their solicitor to equally write a letter of demand for the said sums. This against this backdrop that claimants originally commenced this action by a general form of complaint filed on 13th of March 2020, and it was subsequently amended by an order of court refiled on the 28th of January 2022, wherein claimants claimed the following release against the defendants. 1. An order directing the defendants to pay the total sum of 72,030,211 naira each kobo, being the total amount outstanding as salary arrears, severance, and furniture allowances, which the claimants are legally entitled to be paid as former councillors or ex-political office holders in Okene Local Government Council from 2013 to 2016 political dispensation. 1A, an order of mandatory injunction directing the defendants to pay 700 naira, being their entitlements under the local government political office holder salary structure, as approved by the Revenue Mobilization, Allocation and Fiscal Commission 2009, by which their accommodation constituency, personal assistance, furniture and severance of 15%, 5%, 50%, and 50% respectively. 2, an order of perpetual injunction restraining the defendants, their agents, privys, or anybody acting through them or on their behalf from withholding the payment of said salary arrears, severance, and furniture allowances, as well as other benefits due to the claimant as our government council from 2013 to 2016 as directed to be paid, the Revenue Mobilization, Allocation, and Fiscal Commission, and which directive was further approved by the Kogi State House of Assembly. 3, 21% percentage interest on the said outstanding salary arrears and allowances of 72,030,211 naira 80 kobo from the commencement of this suit till the delivery of the judgment thereof, and 20% interest thereof from the date of the judgment on the judgment sum is being liquidated and finalist and omnibus that the remuneration of certain public political officers amendment law number 1 is special assistance to local government chairman. It maintained that the revenue mobilization salaries and allowances for local governments are prescribed under item N of part 1 of the 3rd schedule of the Constitution of the Federal Republic of Nigeria 1999 as amended, and its powers to prescribe salaries is limited to only officers mentioned in sections 84 and 124 of the Constitution. It also maintained that the Commission also lacks the power to prescribe severance, allowance, and benefit for local government councillors off. So I will have to continue from where I stopped. The first defendant averred that the extant law on remuneration of public office holders in Nigeria does not apply to claimants, and the resolution of the Kogi State House of Assembly as captured in the letters dated 25th of May and 4th of October 2006 respectively, does not have the force of law to be the basis of a claim right, and that the said letters are not applicable to claimants who served for 2013 to 2016. Claimants are not entitled to pay any severance and furniture allowance, on the basis of Kogi State House of Assembly resolution, which does not have the force of law. According to the first defendant, the claimants are not entitled to the sum claim as monthly salaries, and that the sum claimants were paid by OKU Local Government Council on behalf of the first defendant was part payment of furniture and service allowances. It also maintained that claimants refused to attend the meeting, which was scheduled after the receipt of the claimant solicitor's letter. He then maintained that the first defendant is not indebted to the claimant in the sum of 74,691,854 naira, and that the claimants are not entitled to any of the relief sought. The second defendant, in response to the claimant's claims, filed a statement of defense, and it also averred that claimants are former councillors, admitted that they are former councillors and political office holders whose severance allowances and arrears have been paid in full, as partly admitted by them, and as such cannot mislead the court. It was further averred that claimants are blowing hot and cold as they do not know under which remuneration law they were paid allowances. It was equally the position of the second defendant that the House of Assembly is constitutionally empowered to approve and legislate on any recommended fiscal policy or law in respect of civil servants and appointees in the state. They also averred that there was no directive from Kogi State House of Assembly as to remuneration of claimant, as no fiscal law was domesticated by the House of Assembly to that effect, and it is the duty of the executive and not the legislature to determine their salaries. According to the second defendant, all 11 ex-councillors and all other political office holders did not join in the suit because they know they have been paid, and the judgment of the Court of Appeal delivered by the Court of Appeal on 23rd of October 2015 made no consequential orders for the payment of claimant salaries. It was the further position of the second defendant that salaries and allowances are usually paid for work done, and the claimants cannot ask the court to preside over a matter already decided by the Court of Appeal. It was also stated that the claimants from their respective statement of account were actually paid for January 2015, contrary to their assertion. It is also part of its position that claimants were paid in excess of their entitlement. It further maintained that claimants lack the legal competence to compute and or make laws in respect of fiscal entitlements, as this is within the legislative competence of the State House of Assembly. It was averred that claimants are not entitled to the sums claim, and as such, their case should be dismissed in its entirety. At the close of pleadings, parties, be their respective counsel, inform the court of their desire to adopt the argument on record procedure pursuant to Order 38 Rule 33 of the rules of this court. By this special procedure, which is pursuant to Order 38 Rule 33, parties have dispensed with the need for oral hearing, and the case is to be tried on record by considering the pleadings of parties and documents front-loaded. Subsequently, parties were ordered to file their respective written addresses, and as it is customary to do in this type of procedure, claimants file first and have reduced their arguments in support of their case into the body of this judgment. The first defendant did not file. Meanwhile, the second defendant filed and have reduced the argument of the second defendant into the body of this judgment. So I'll go straight to the decision of the court. After an in-depth perusal of the general form of complaint and the accompanying processes, together with the statement of defense of the defendants and the final written addresses on behalf of the claimants and and the second defendant, I am of the respectful view that the issues, the determination of which will do justice to that. One, whether the claimants have local standing to institute this action. Two, whether the claimants are by the judgment of the Court of Appeal, Abuja Division, in appeal number CA/A/194/2015, case of PDP versus APC, and others are entitled to payment of salaries. And three, whether or not claimants have proven their case. Before the resolution of the issues so formulated, I find it necessary to address the consistent manner in which defendants generally, ditto the defendants in this case, entered appearance in this case. Just a minute. The first, on the 18th of November 2020, filed a memorandum of conditional appearance. The second defendant on the 12th day of November entered appearance via the memorandum of conditional appearance. The law is settled beyond peradventure that a memorandum of conditional appearance is a mode of entering conditional appearance, and which is an appearance under protest to object to the jurisdiction of the court. See the case of CGG Nigeria Limited and Eronini, citation captured, Enterprise Bank and Aroso, citation captured. Although the first defendant filed a notice of preliminary objection to the jurisdiction of this court, but the notice of preliminary objection was never moved and was later withdrawn, which means that there is no objection to the jurisdiction of this court by the first defendant. The court have held that if after the entry of conditional appearance, legal counsel for the defendant at no time objected to the court's jurisdiction and proceedings proceeded, the appearance of the defendant to the proceedings will be taken as unconditional, thereby making the entry of conditional appearance worthless. Therefore, such a defendant is deemed to have submitted to the jurisdiction of the court. See the case of UBN versus Alma Properties Limited. It is in view of the above position of the law that it goes without saying that the first defendant in this case is deemed to have submitted fully to the jurisdiction of this court, notwithstanding their entry of conditional appearance. I so hold. It is a submission of learned counsel on behalf of the second defendant by paragraphs 3.1, 3.2, 3.47, and 3.48 that the claimant's action is bereft of cause of action, and as such, they lack the local standing to institute this action. Let me first start by telling counsel that though local standing and reasonable cause of action are linked to jurisdiction, they are not correlative, in the sense that standing to sue is distinguishable from reasonable cause of action. Whether a party has reasonable cause of action is different from whether he has local standing. See the case of Idumegwa and Ibezim, citation captured, the case of Sehidemi and Governor of Lagos State, citation provided. Thus, local standing does not depend on whether he has reasonable cause of action, even if the statement of claim must, though the statement of claim must disclose both. However, sometimes they may be woven depending on the facts averred by a party in the statement of facts. See the case of Ayorin and Kuforiji, citation captured. The law is settled that cause of action means the fact or facts which establishes or give rise to a right of action. Put differently, it is a factual situation that gives an aggrieved person the right to judicial remedy. It arises the moment a wrong is done to a person, giving him right to pursue a judicial relief. See the case of Maza and Awuna, citation captured. The law is equally right that the term local standing, otherwise known as standing to sue, is a party's right to make a legal claim or seek judicial enforcement of the right in a law court. And for a person to have local standing, he must be able to show that A, he has suffered some injury by the conduct challenged, in the sense that there must be a dispute between parties. And B, the action is justiciable and within the ambit of the provisions of the law. See the case of Ogenuebo and Governor of Delta State, citation provided. The case of BB Akuba and Sons Limited versus Orthopedic Hospital Management Board, citation provided. Thus, the question of local standing is concerned with whether a person has a right to sue to protect a civil right or obligation. See also the case of Ogenuebo and Governor of Delta State, Sobra. It is an originating process, and the statement of claim or facts or the affidavit in support of the originating summons that will be considered in determining whether a person has locus standi or not. See the case of Fidelity Bank and Imbacha citation capture. It is right that a cause of action constitutes a bundle of facts and circumstances giving rise to the claimant's enforceable claims against the defendant. In determining whether a statement of claim discloses a reasonable cause of action, just like with locus standi, the court ought to examine the statement of facts and see whether on the face of it, it discloses facts which, if proved, will entitle the claimant to a remedy. See the case of Society Big SA versus Chazin Industries Limited citation provided. It is worthy of note that the question whether a person will succeed or not is irrelevant in the determination of locus standi. Thus, it does not matter if it appears weak or the action may not succeed. Therefore, the submission of learned counsel that the claimants do not have the cause of action and as such lack locus standi because the law they are relying on is a non-existent law, is not tenable. From a perusal of the amended statement of facts of the claimants, they aver that they were members of Okene local government who served during the 2013, they are members of the Council of Okene local government. Just a minute. Who served during the 2013-2016 political dispensation, whose election was nullified by the High Court Kutunkorfi, and the decision was set aside by the Court of Appeal. They averred that during the period they were out of office, they were owed salaries from January 2015 to October 2015. By this, claimants have shown sufficiently that they suffered injury by the conduct or breach of their civil liability by the defendants and thus have locus to protect their civil right to be paid as councillors. No one else has locus to enforce their right to be paid except them. By those averments, they were equally able to show the facts which led to their claims against the defendants, and this constitutes their cause of action in this case, which is reasonable. It is therefore erroneous for counsel to submit that claimants do not have reasonable cause of action and thus no locus standi. Submission of counsel, no matter how attractive, is a misconception of the principle of locus standi. It is equally necessary for me to address the state of pleadings of parties in this case. The first defendant in this case had filed a statement of defense to the initial statement of facts of the claimant before the originating process, and the statement of facts were amended pursuant to the order of court. However, he did not file a consequential amendment to his joint statement of defense after the claimants amended their statement of facts. The law is settled that upon an amendment of the statement of claim or facts, as in this case, the defendant is at liberty to amend his statement of defense without leave of court, insofar only as is necessary to meet the facts introduced by the amendment. However, where he fails to file a consequential amended statement of defense to the amended statement of facts, he cannot be taken to have joint issues with the claimant on the new issues raised in the amended statement of facts. Statesman and First Bank and Order citation captured, the case of Mobile Oil Nigeria PLC and IAL 36 Inc. citation captured. This means that the first defendant did not respond to the new averments of claimant occasioned by the amendment of their processes. This is not to say that a defendant is obliged to file a consequential amendment when the claimant amends his process, neither does the mere fact that the defendant has not amended his process to answer to the new issues raised in the amended statement of fact be taken to mean that he has not defended the action. See the case of Afemike and others versus Stanbic IBTC, citation captured. The second defendant, on the other hand, had earlier filed its statement of defense to the initial statement of facts. See pages 156 to 159 of the record. It equally responded to the amended statement of facts by filing a consequential amendment to his statement of defense, though the process was erroneously termed second defendant's statement of defense and not consequential amendment, which it purports to be. See pages 631 to 635 of the record. Thus, one can validly say that the second defendant joined issues with the claimants on the new averments in the amended statements of facts. It is germane before the resolution of the issues from later to reiterate here also, As stated earlier, the parties in this case consented to and adopted the argument of record procedure pursuant to the 38 to 33 of the rules of this court, which is to the effect that parties have dispensed with oral hearing of the case and consented that the case be decided on record. The effect of this is that the court will decide the case based on the pleadings and documents front-loaded by each of the parties, and those documents and which documents have not been objected to by way of a schedule prescribed by the rules of this court. Now it is expedient for the resolution of the second issue for determination for me to first state that it is not stipulated by either side that claimants were ex-councillors or political office holders who were elected in Okene Local Government Council between 2013 to 2016 political dispensation. It is equally not disputed that the appellate court had nullified the decision of the High Court Kotun Karfi, which annulled the election of the claimants in this case. In fact, the said judgment is before this court as an exhibit. However, the point of this dispute between parties is whether or not the judgment of the appellate court confers benefit of any payment of salaries to the claimants. According to claimant by the amended statement of fact, due to the judgment of the High Court Kotun Karfi, which was later set aside on appeal, they were not paid their salaries from January 2015 to October 2015. They maintained that at the time they left office in 2016, they were paid other entitlements except arrears of salaries from January to October 2015. See paragraph 28 of the amended statement of facts. The first defendant, by paragraph 18 of his statement of defense, had denied claimants' averment as regard being owed salaries and put them to the strictest proof. This to me is not a valid denial of the non-payment of salaries to the claimant within those periods. The second defendant, by paragraph 10 of the consequential amended statement of defense, averred in response that the judgment of the Court of Appeal on 23rd of October 2015 made no consequential order as to payment of claimant salaries for the period they were out of office. It equally averred by paragraph 12 of the said consequential amended statement that claimants cannot ask the court to sit on a matter that has already been decided by the Court of Appeal. According to learned counsel for the second defendant, Mr. O.W. Obaido, since the decision of the Court of Appeal contains no consequential orders as to payment of salaries to the claimants, claimants cannot read into the judgment what is not contained therein. Thus, claimants are not entitled to be paid for 10 months they were out of office. In fact, learned counsel, Obaido Esquire, by paragraphs 3.9 and 4.0 of its address, submitted that the judgment of the Court of Appeal should be interpreted, given the words used their plain meaning. Judicial powers are vested in courts by virtue of the provisions of Section 6 of the Constitution of the Federal Republic of Nigeria as amended, hereafter referred to as the Constitution. Section 6, subsection 6, paragraph B of the Constitution provides thus, and I quote, "The judicial powers vested in accordance with the foregoing provisions of this section, B, shall extend to all matters between persons or between government or authority and any person in Nigeria, and to all actions and proceedings relating thereto, for the determination of any question as to the civil rights and obligations of that person. Judicial power of the court extends to all matters between persons," unquote. It is clear that it is not only government or authority that are covered in the ambit of judicial powers. Persons other than government and authority are also encapsulated within judicial powers of court, and no such person shall be able, by its domestic arrangement or agreement, to remove itself from the general jurisdiction of the competent court. The point must be made that while judicial powers vested in superior courts of record, including this court, does not extend to this court being a court of subordinate jurisdiction to the Court of Appeal, to sit on appeal or on the decision of the Court of Appeal, or to subject same to interpretation. This is because judgments of court are unlike documents. See the following cases: Igbado and another versus Keystone Bank, citation captured. However, this court can look at and apply the exact terms of the judgment to the case at hand by expressing its opinion on the beliefs or taking into account the said judgment. See the cases of Igbado and another and Keystone Bank Supra, the case of Nigeria Industrial Development Bank and another citation captured. It is in my humble view that in view of the Court of Appeal judgment setting aside the order of the Kotonkarafi Court, nullifying the election that brought claimants in, claimants are thus entitled to be paid for the 10 months they were out of office by virtue of the judgment that was set aside because same was invalid. Thus, claimants never left office and as such are entitled to be paid for those periods. Fagwan and other versus Idigbe and other citation captured. The arguments of learned counsel on behalf of the second defendant in his final written address that claimants are not entitled to be paid because the judgment of the Court of Appeal contains no consequential orders as to payment of salaries is a misconception because claimants are not seeking an interpretation of the said judgment, but that it should be applied to their case, which is what this court has done. Thus, question 2 is answered in favor of claimants. The question then remains how much they are entitled to be paid and what the modalities of the payments are. In addressing this issue, I will rely on section 7 and 4(6) of the Constitution. Section 7 of the Constitution provides that the system of local government, democratically elected local government, is guaranteed under the Constitution, and accordingly, the government of every state shall, subject to section 8 of the Constitution, ensure their existence under a law which provides for the establishment, structure, composition, finance, and functions of such councils. See the case of Friday and Governor of Ondo State citation captured. Claimants in support of how much they are entitled to be paid relied on the provision of remuneration of certain political officers law, Amendment Law Number 1, 2006, herein after referred to as the Amendment Law. They equally relied on the remuneration package prescribed by Revenue, Mobilization, Allocation, and Fiscal Commission. The first defendant, by paragraphs 4 and 5 of its statement of defense, averred that the said amendment, Mr. Onoja, please mute your phone.
I'm sorry.
The first defendant, by paragraphs 4 and 5 of his statement of his defense, averred that the said amendment law does not apply to claimants, but to special assistants of local government council. Let me first say that I perused the said amendment law and I find that it is true as posited by the first defendant that the said amendment law does not apply to special assistance as posited by the first defendant. In fact, I've equally perused the provisions of remuneration of certain public and political office holders law 2000, which is hereafter referred to as the principal law, as amended by the amendment law. And I find that the said law only applies to local government executives, such as chairman, vice chairman, supervisors of local government, secretary, local government, and special assistants to local government council, whose salaries and other remuneration and allowances shall be charged upon the consolidated revenue fund of the state. See sections 1, subsection 4, and 3 of the principal law as amended. Although I find that Schedule 3 to the principal law as amended captures the fringe benefits, which include severance, furniture, constituency, allowances, and other benefits of persons, including supervisory councillors, who are listed as number 3 on the table in Schedule 3 to the law, and which table as seen in Schedule 3 is stated therein to be in accordance with the approved structure of Revenue, Mobilization, Allocation, and Fiscal Commission. I am of the opinion that claimants are not supervisory councillors to make Schedule 3 of the principal law as amended applicable to them because they are elected councillors as shown in their several certificate of return on record. Therefore, it is my view that both the amendment and the principal law both the amendment and the principal law do not apply to claimants to be able to take refuge under them. Now, assuming that claimants can even take cover under Schedule 3, of law as supervisory councillors, can one say that the House of Assembly, Kogi State, has the necessary legislative powers to make such laws providing for remuneration of local government executives to be charged upon the consolidated revenue fund of the state? It is worthy of note that it is the position of the first defendant by paragraph 6 of its amended statement of defense that the Revenue Mobilization, Allocation and Fiscal Commission lacks the power to prescribe salaries and allowance for local government councillors. I am mindful of the submission of learned counsel on behalf of second defendant in paragraph 3.20 of his final written address that local government political office holders' salary structure as approved by Revenue Allocation, Mobilization and Fiscal Commission 2009 is not valid for being in contravention of the provisions to paragraph 32B of the Constitution. It was submitted by learned counsel on behalf of the second defendant that the letter dated 10 February 2006 on which claimants are relying on is also null and void as Kogi State House of Assembly has no power to make same. It was equally submitted by learned counsel in paragraph 3.30 of his final written address that Kogi State House of Assembly acted or traversed their powers by prescribing a salary higher than what the remuneration package for political, public, and judiciary officers are entitled. In fact, learned counsel urged the court to declare that the law enacted by House of Assembly or traverses its powers and as such inconsistent with the provisions of the Constitution. He referred the court to the provisions of paragraph 32D of part 1 of the third schedule and section 124 of the Constitution. In view of the position of the first defendant in its statement of defense and the submission of learned counsel on behalf of the second defendant in its final written address, it is therefore expedient for me to consider the constitutionality of the powers of Revenue Allocation, Mobilization, Allocation, and Fiscal Commission to prescribe salaries for councillors vis-a-vis its recommend salary structure as contained in the 2007 and 2009 remuneration, which, and the constitutionality of the said law, he referred the court to the provision of paragraph 32D of part 1 of the third schedule and section 124 of the Constitution. It is in view of the position of the first defendant in the statement of defense and submission of learned counsel on behalf of the second defendant that it is expedient for me to consider the constitutionality of the powers of Revenue, Allocation, Mobilization, and Fiscal Commission to prescribe salaries for councillors vis-a-vis its powers to recommend a salary structure as contained in the 2007 and 2009 recommendation and the constitutionality of the said law passed by Kogi State House of Assembly vis-a-vis its powers under the Constitution. Section 4, subsection 6 of the Constitution vests the legislative powers of the state of the Federation in the House of Assembly of every state. Section 4.7c of the same Constitution provides further that the House of Assembly of the state shall have power to make laws for the peace, order, and good government of the state or any part thereof with respect to any other matter in respect of which it is empowered to make laws in accordance with the provisions of the Constitution. Section 124 of the Constitution empowers the House of Assembly to prescribe such salaries and allowances payable to the holders of the offices mentioned in the section, but not exceeding the amount as shall have been determined by the Revenue, Mobilization, Allocation, and Fiscal Commission. And as such salaries and allowances payable to the holders of the offices mentioned shall be charged upon the Consolidated Revenue Fund of the state. It was in pursuance of this that Kogi State House of Assembly enacted remuneration of certain public and political office holders law of Kogi State 1999, hereafter referred to as, wherein it has been referred to as the principal law, which was amended by the first amendment of 2000 and the second amendment of 2006, which was relied on by claimants in this case. Claimants in this case by paragraph 5 of the amended statement of fact relied on remuneration of certain public/political officers law amended law number 1, 2006, which is also the second amendment. The first defendant by paragraph 4 and 5 of its statement of defense averred that the said second amendment law does not apply to claimant, but to special assistants of local government council. Let me first say that it is true as posited by the first defendant that the said second amendment law relied on by claimant does not apply to them, but to special assistants as posited by the first defendant. In fact, what applies to claimant is the principal law as amended by the first amendment 2000. However, there is no doubt from the provisions of the said principal law that the salaries prescribed therein are to be charged from the Consolidated Revenue Fund. The second amendment law 2006 amended the list of those to benefit from the remuneration package to include special assistance to local government. It equally amended the provision of Schedule 1 of the law to include special assistance to local government on basic salary of 310,729 naira. In the same vein, provisions of Schedule 3 of the principal law was also amended to include special assistance. Section 2 of the second amendment law 2006 did the same. On the table of allowances and fringe benefits of local government executives in Schedule 3 as amended by the second amendment, supervisory councillor as number 3 on the list, see page 364 of the record. It is clear from the provision of the principal law as amended by the first amendment 2000 and the second amendment 2006 that the salaries of the political office holders in the local government council, which includes councillors, will be drawn from the Consolidated Revenue Fund of the state. I am mindful of the position of the first defendant by paragraph 6 of the statement of defense that Revenue Mobilization, Allocation and Fiscal Commission lacks the power to prescribe salaries and allowances for local government councillors. I do not also lose sight of the submission of learned counsel for the second defendant on the same issue. It was submitted that the letter dated 10 February 2006 on which claimants are relying on, just a minute, is also null and void as Kogi State House of Assembly has no power to make same. It was equally submitted that the Kogi State House of Assembly acted or traversed its powers. Council referred the court to the provisions of paragraph 32D, part 1 of the third schedule and section 124 of the Constitution. And it is in view of the positions of both counsel that this court will address this contention in this manner. I will address this contention first by stating that this court is empowered to take judicial notice of judgments of courts. See the case of Anyakin Due and Augustine, citation captured. The case of Saraki and Kutoyi, citation equally captured. The current state of the law is as decided by the Supreme Court on the 4th of February 2022. In the case of Charles Nwokedi and Anambra State Government in another, citation captured, where the court held that the power bestowed on the legislature, like a State House of Assembly, to make, enact, and pass laws is undiluted so long as any laws passed by it is within its own legislative competence and authority. It is not only that the legislature can enact laws, it can also amend any existing law passed by the arm of government as circumstances may permit, whereas it is the duty of the legislature to enact laws, that of the judiciary is to interpret the law so made. More emphatically, as it concerns the power of the House of Assembly of the state to prescribe remuneration of local government council, political office holders, and the power of the Revenue, Allocation, Mobilization, and Fiscal Commission to make recommendations for the remuneration of local government council, political office holders. I take the liberty to capture salient parts of the decision of the Apex Court as it relates to this case for the sake of clarity, from pages 52 to 67 thus. I quote, "A careful perusal of the submission of learned counsel on both sides will easily reveal that this issue simply calls to question the extent or limit of the legislative powers or competence of Anambra State House of Assembly as donated to it by the Constitution of Nigeria to fix salaries of public officers and political office holders which shall be charged upon the Consolidated Revenue Fund of the state. To start off, there is no dispute that by the combined effects of sections 4, 6, and 7A and of the Constitution of the Federal Republic of Nigeria as amended, the State House of Assembly is empowered to make laws for the peace, order, and good government of the state. Section 4, subsection 6 reads thus: the legislative powers of the state of federation shall be vested in the House of Assembly of the state. The court went on to state that section 7A states that the House of Assembly of the state shall have power to make laws for the peace, order, and good government of the state or any part thereof with respect to the following matters. That is to say, A, any matter not in the exclusive legislative list set out in part 1 of the second schedule to this constitution. B, any matter included in the concurrent legislative list set out in the first column of part 2 of the second schedule to this constitution, to the extent prescribed in the second column opposite thereto. C, any other matter with respect to which it is empowered to make laws in accordance with the provision of this constitution. Consequent upon the general legislative powers conferred upon the State House of Assembly by subsections and section 4 of the Constitution, Section 124 thereof empowers the State House of Assembly to prescribe remuneration for certain categories of public officers and political office holders. Section stipulates inter alia that there shall be payable to the holders of the offices mentioned in this section such salaries and allowances as may be prescribed by the House of Assembly, but not exceeding the amount as shall have been determined by the Revenue Mobilization, Allocation, and Fiscal Commission. 2, the salaries and allowances payable to the holders of the offices mentioned shall be charged upon Consolidated Revenue Fund of the state. 3, salaries payable to the holders of the said offices and their condition of service orders and allowances shall not be altered to their disadvantage after their appointment. 4, the offices aforesaid are offices of the governor, deputy governor, the Auditor General of the state, Auditor General of local government councils of state, chairman, and members of the following bodies, that is to say, the State Civil Service Commission, the State Judicial Service Commission, the State Local Government Service Commission. Pursuant to the provisions of Section 124 of the Constitution, the Anambra State House of Assembly proceeded to enact Law Number 7 of 2001 to provide for salaries of public officers in Anambra State and for related purposes. The Law Number 7 states inter alia thus: whereas Section 124(1) of the Constitution of the Federal Republic of Nigeria, that there shall be paid to the holders of the offices mentioned in this section such remuneration and salaries as may be prescribed by House of Assembly, but not exceeding the amount as shall have been determined by Revenue Mobilization, Allocation, and Fiscal Commission, be it enacted by the House of Assembly of Anambra State of Nigeria. 1, this law may be cited as Anambra State Public Officers Salaries Law 2001 and shall be deemed to have come into effect on 29th of May, 1999. Section 6, the offices aforesaid are those of governor, deputy governor, secretary to the state government, and so on, chairman of local government, vice chairman, secretary to local government, supervisors, special advisors or PA to the chairman, leader of local government legislative council, deputy leader, councillors, unquote. It is manifest from the above that Law Number 7 of 2011 include councillors as one of the political office holders whose salaries and remuneration are to be charged upon the Consolidated Revenue Fund of the state. Learned counsel for the appellant hearing. The court continued by saying that learned counsel for the appellant hearing has argued that a councillor is a political office holder. That may be so. The issue now is whether he comes within the purview of those officers whose salaries shall be determined and charged upon the Consolidated Revenue Fund of the state by Revenue Mobilization, Allocation, and Fiscal Commission, so as to warrant judgment being entered in his favor. To answer this question, I must have recourse to the provisions of Revenue Mobilization, Allocation, and Fiscal Commission Law, Cap 392, Laws of Federation of Nigeria 99, hereafter RMAFC Act, to determine whether the appellant is actually a beneficiary. Section 6 of the RMAFC Act stipulates the powers of the Commission as regards remuneration. It provides inter alia, thus, the commission shall have power to determine the remuneration of holders of offices as specified in parts A and B of the first schedule to this act. Hereunder reproduces parts A and B of the first schedule to the RMAFC Act. First schedule, offices, President, Vice President, Chief Justice of Nigeria, Justice of Supreme Court, President of the Court of Appeal, Justice of the Court of Appeal, Chief Judge of the Federal, and by the third amendment, the President of the National Industrial Court of Nigeria, Judge of Federal Court, Judge of the Federal Court in the Federal, Judges of the National Industrial Court of Nigeria, Judges in the Federal Capital Territory, Grand Cadi and Cadis of the Sharia Court of Appeal of the Federal Capital Territory, President and Judges of Customary Court of Appeal of the Federal Capital Territory, Inspector General of Police, Auditor General of Federation, and the chairman and members of the following executive bodies, namely Code of Conduct Bureau, Federal Civil Service Commission, National Electoral Commission, Federal Judicial Service Commission, National Population Commission, Revenue Mobilization, Allocation and Fiscal Commission, the Nigerian Police Council, and the Public Complaints Commission. Offices, Governor, Part B offices, Governor, Chief Judge of a State, Judge of the High Court of the State, Grand Cadi and Cadi of Sharia Court of Appeal of the State, President and Judge of Customary Court of Appeal of the State, Auditor General of the State, Auditor General of Local Government Councils of the State, and chairmen and members of the following bodies, that is to say, the State Civil Service Commission, State Judicial Service Commission, and the State Local Government Service Commission. It follows, therefore, that Section 61D of the Revenue Mobilization, Allocation, and Fiscal Commission Act makes no mention of a councillor as one of those public officers or political office holders to benefit from payment of salary and emolument from the Consolidated Revenue Fund of the state, and whose salary shall be fixed by the Revenue Mobilization, Allocation, and Fiscal Commission. The argument of learned counsel for the appellant is that the scope of political office holders whose names were not mentioned have been expanded by Section 61F of the Revenue Mobilization, Allocation, and Fiscal Commission Act, which provides that the Commission shall have powers to discharge such other functions as may be conferred on it by the Constitution of the Federal Republic of Nigeria, this act or any other act of the National Assembly. This stance by learned counsel is with respect untenable. The simple reason is because those other functions that the Commission ought to perform or upon which extra power may be conferred on it by the Constitution, the act or any other act of the National Assembly do not envisage expanding the scope of political office holders or public officers whose names have not been mentioned either by the Constitution, the RMAFC Act itself, or any act of the National Assembly. Assuming, but without conceding, that the scope is to be expanded in clear and unambiguous words, that the scope of it is to be expanded in clear and unambiguous words of Section 61F of RMAFC Act itself, the Constitution or another act of the National Assembly that can expand the scope of powers thereof, and not an inferior legislative house like that of Anambra State House of Assembly. The court continued by saying that I'm therefore in total disagreement with the submission of learned counsel for the appellant that the provisions of Section 32D, Item N, Part 1 of the Third Schedule of 1999 Constitution as amended, expand the scope of the Constitution to include councillors. The section states inter alia that the Commission shall have power to determine the remuneration appropriate for political office holders, including the President, Vice President, governors, deputy governors, ministers, commissioners, special advisors, legislators, and the holders of the offices mentioned in Sections 84 and 124 of the Constitution. The import of Section 32D, Item N, Part 1 of the Third Schedule of the Constitution, which in my view is an assemblage of Sections 84 and 124 of the Constitution of the Federal Republic of Nigeria, as amended, as well as Section 61D of the RMAFC Act is that the inclusion of local government councillors by the Anambra State Law number 7 of 2001 in the list of political office holders or public officers of whom their salaries shall be fixed by the Revenue Mobilization, Allocation and Fiscal Commission and charged upon the Consolidated Revenue Fund of Anambra State is at variance with the expert provisions of 99th Constitution as amended. Learned Counsel for the APD, item N, part 1 of the schedule of the Constitution, as well Benin Council. Please, can you hear me? I have problem with my internet. Can you hear me?
Yes, my lord. We can hear you, my lord.
I'll continue with the phone now. I was quoting the Supreme Court. So I stopped at where the learned jury said, however, let me start from where you can get it. Learned counsel for the appellant had contended as the counsellor of the initial local government. The appellant is a legislator, as envisaged by Section 32D, Item N, Part 1 of the Schedule of the Constitution. As rightly held by the court below, it will appear there was a legislative device to deliberately exclude political office holders like councillors who are legislators, has right on their local government tier of government. However, they are not legislators properly so called, as envisaged by the Constitution in Section 318, subsection 1 thereof, which states that in this Constitution, unless it is otherwise expressly provided, or the context otherwise requires, legislative house means the Senate, House of Representatives, or the House of Assembly, unquote. The Legislative Council of a local government is not mentioned by the Constitution. So by extension, a councillor is not recognized by the Constitution as a member of the Legislative House properly so called. Again, Section 318, subsection 1 of the Constitution as amended, defined public service of the state to mean the service of the state in any capacity in respect of the government of the state, and includes service as mentioned in subparagraphs, paragraph 8 thereunder. What is more, Section 120 of the Constitution, which in subsection 1 established the Consolidated Revenue Fund of the state, stipulates in subsection 2 thereof that no money shall be withdrawn from the Consolidated Revenue Fund of the state, except to meet expenditure that is charged upon the fund by this Constitution, or where the issue of those monies has been authorized by an appropriation law, supplementary appropriation law, or law passed in pursuance of Section 121 of the Constitution. It follows, therefore, that any expenditure that is to be charged upon the fund by this Constitution shall be as stipulated by Section 124, subsection 4 of the Constitution. The consequence of the above is that the inclusion of chairman of local government, vice chairman, secretary to local government, supervisors, special advisors, or PA, to the chairman, leader of the local government legislative council, deputy leader, and councillors by the Anambra State Law number 7 of 2001, in the list of political office holders or public officers whose salaries shall be fixed by the Revenue Mobilization Allocation and Fiscal Commission and charged upon the Consolidated Revenue Fund of Anambra State, is against the express provision of Section 124, subsection 4 of the Constitution as amended. The main contention here is whether Anambra State Public Officers Law number 7 of 2001 was enacted or traversed the Anambra State House of Assembly, and is as a result inconsistent with the provisions of the 1999 Constitution as amended. It is settled law that the power bestowed on the legislature, in this case, the Anambra State House of Assembly, to enact, and pass laws undiluted so long as any laws passed by it is within its own legislative competence and authority. Not only can the legislature enact laws, it can also amend any existing law passed by the arm of government as circumstances permit. But where a statute is enacted in breach of the Constitution, the court must come in to stop the breach. This the court can do only by one or more parties seeking court's jurisdiction to declare the statute void. By the express provision of Section 4, subsection 8 of the Constitution, the exercise of legislative powers by the National Assembly or by a State House of Assembly shall be subject to the jurisdiction of the court. In the instant appeal, the Anambra State Public Officers Salaries Law, enacted by Anambra State House of Assembly, which purported to fix the salaries and emoluments of chairmen and councillors of local governments, amongst others, and charge same upon the Consolidated Revenue Fund of the state, was enacted or traversed the powers of Anambra State House of Assembly. and inconsistent with the express provisions of Section 124, subsection 4 of the Constitution as amended. It said Anambra State Public Officer Salaries Law, number 1 of 2001, to that extent, to the extent of its inconsistency with the Constitution is null and void, and the trial court had the requisite jurisdiction to strike down such inconsistent legislation. The action of the trial court is undoubtedly justifiable, having regard to the provisions of Section 1, subsection 3 of the Constitution as amended, that prohibits the existence of any other law that is inconsistent with the constitutional provision, and declaring such other law shall be void to that extent. Inconsistency, to the extent of its inconsistency with the Constitution, as well as Section 4, subsection 8 of the Constitution as amended. This court had given recognition to this supremacy and had expatiated on the Constitution through various judgments in its interpretative jurisdiction. The Constitution is described as the ground norm and the fundamental law of the land. All other legislation in this country take their hierarchy from the provisions of the Constitution. It is not a mere common legal document. It is an organic instrument which confers powers and also creates rights and limitations. It regulates the affairs of the nation, state, and defines the powers of the different components of government, as well as regulating the relationship between citizens and the state. Once the powers, rights, and limitations under the Constitution are identified as having been created, their existence cannot be disputed in a court of law. But the extent and implications may be sought to be interpreted and explained by the court. The provisions of the Constitution take precedence over any law enacted by the National Assembly, even though the National Assembly has power to amend the Constitution itself. It continued by saying that it is, in my considered view, that this court has sufficiently demonstrated that the amended 1999 announced on the constitutionality of any law made by legislature, such as the Anambra State House of Assembly in the instant case, disobey the provisions of the said Constitution. Furthermore, I am fortified in my view that where the Constitution itself expressly vests in the courts the power to pronounce on the constitutionality of the law vis-a-vis its provisions, then the court cannot be said to be acting without jurisdiction in discharging the duty imposed on them. Against the backdrop of all that has been stated, I hold without hesitation that the trial court had the jurisdiction to entertain and pronounce on the constitutionality of the Anambra State Public Officer Salaries number 7 of 2001. All that the trial court did in this regard was in the discharge of the power vested in it by the Constitution itself. The trial court, and indeed all courts in Nigeria, being the primary custodians of the Constitution, cannot close their eyes to the desecration of the Constitution by any stated that I am therefore in concert with the court below when it affirmed the decision of the trial court that the Anambra State House of Assembly went on the frolic of its own when it enacted the Anambra State Public Officer Salaries Law number 7 of 2001 and purportedly charged the salaries and remuneration of chairman of local government, vice chairman, secretary to local government, supervisor, special advisor or PA to the chairman, leader of local government legislative council, deputy leader and councillors to the consolidated revenue fund of the state, notwithstanding that it was at variance with the express provisions of Section 124, subsection 4 of the Constitution of Federal Republic of Nigeria 1999 as amended. This issue is resolved against the appellant, unquote. I've taken the pain to capture all the above pertinent portion of the well-reasoned decision of the Supreme Court per Aboki GSC, now retired, in order to lay bare the current position of the law as regards the extent of the powers of the State House of Assembly in fixing the salaries and emoluments of chairmen and councillors of local government, amongst others, and charge same upon the Consolidated Revenue Fund of the state, and also the extent of the powers of Revenue Mobilization, Allocation, and Fiscal Commission to recommend remuneration of chairmen and councillors of local government, amongst others, to be charged upon the consolidated revenue of the state. Although no two cases are the same, however, the above case of Imbo KD and Anambra State Government Supra is similar in all respect with this instant case, in the sense that the claimant hearing was a former councillor who was equally seeking to be paid his remuneration based on the Anambra State Public Officer Salary Law number 7 of 2001, which is similar in most respects with the principal law as amended in this case, and which remuneration was based on the recommendation of the Revenue Mobilization, Allocation and Fiscal Commission. Claimants in this case are equally ex-councillors seeking for payment of their remuneration from January to October 2015, based on the principal law enacted by Kogi State. They are equally claiming other remuneration based on the approval of the House of Assembly by resolution for the implementation of the 2009 recommendation made by the Revenue Mobilization Allocation Commission as seen at page 371 of the record. It is thus clear as reasoned supra that the case at hand is similar in most respects with the present suit. I am mindful of the previous decisions of this court as they relate to payment of remuneration, severance benefits, and other allowances to ex-political office holders in local government councils in Kogi State, one of which is an unreported suit number NICN/LKJ/31/2019, the case of Honorable Salami Lamidi and 21 others, and Ugori Magogo Local Government Council and another, judgment that was delivered on 26th of March 2021, wherein this court decided that the claimants therein who were ex-councillors, supervisors, special assistants in Ugori Magogo Local Government Council during 2008 to 2011 political dispensation were entitled to certain sums of grants allowances based on the local government political office holder salary structure as approved by the Revenue Mobilization, Allocation and Fiscal Commission in their remuneration of 2009, and which structure the claimant in this case are equally relying on. I'm equally mindful of the earlier decision of this court in an unreported suit number NICN/LKJ/24/2020, the case of Honorable Sule Jima and 6 others versus Adabi Local Government Council and another, judgment that was delivered on the 10th of June 2021. In that case, the court considered the provisions of the Second Amendment law and reviewed the remuneration package and the review remuneration package for political public office holders of 2007, which the claimant in that case equally relied on, to find that truly claimants in that case were entitled to be paid severance and other allowances due to them as former political office holders in Adabi local government from 2004 to 2007 political dispensation, although other monetary claims failed for lack of proof. The point needs to be made that what shaped the said decision of this court in those 2 cases was the state of the law as at that time, which was as decided by the Court of Appeal, per Mojid Owade JCA, now retired, in the case of Anambra State Government and another, versus Gloria Obiora, wherein the Court of Appeal inter alia held thus. On issue number 2, then a counsel for the appellant was equally on the wrong footing when he argued that the provision of Section 4 of Anambra State Law number 7 of 2001, which charged the payment of emolument of local government councillors on the Consolidated Revenue Fund, is inconsistent with the provision of Section 124 of the Constitution. Then a counsel for the appellant contended that the remuneration of offices to be charged on the Consolidated Revenue Fund under Section 124 of the Constitution is prescribed by the provisions of Section 124.4, which mentioned the State Local Government Service Commission, but not local government councillors. To the contrary, I am of the considered opinion that the provision of Section 124 of the Constitution is inclusive and not exclusive. In other words, the provision of Section 124 of the Constitution guarantees that the salaries and emolument of those officers mentioned in Section 124.4 are charged and paid under the Consolidated Revenue Fund, but does not preclude the charging and payment of other salaries if and when authorized by law to be charged under the Consolidated Revenue Fund. It is for this reason that the provision of Section 120, particularly 120 subsection 3A of the same Constitution, declare that no monies shall be withdrawn from any public fund of the state other than the Consolidated Revenue Fund of the state, unless the issue of those monies has been authorized by law of the State House of Assembly. No money shall be withdrawn from the Consolidated Revenue Fund of the state or any other public fund of the state, except as prescribed by the House of Assembly. It is clear that the provision of Section 124 of the Constitution does not exclude or prescribe the payment of salaries of other public officers otherwise than those mentioned in Section 124.2. The text of, 124.4. The text of the statute or rule is a primary essential source of its meaning. The words of the governing text are paramount concern. In their context is what the text means. We cannot depart from the words of the law. The verbis legis non est residendum. Udo Domajes rightly put it in the case of Nafi Rabiu and the state of the Constitution, where clear and unambiguous must be given in plain, evident meaning, and that a constitutional provision should not be construed so as to defeat its evident purpose. The instant case, the trial judge was right to have held, first, that Section 4 of the law number 7 of 2001, as indeed the entire law was passed by a number of State House of Assembly. The payment to councillors therein from the Consolidated Revenue Fund of the state is prescribed by the State House of Assembly. This is pursuant to its undisputed power under Section 124 of the Constitution, and also that it is this power circumscribed by Section 124.4 of the Constitution. A close look at the said section will reveal that it is not meant to prohibit the payment of salaries of persons other than those stipulated therein from the Consolidated Revenue Fund. If that was the intention of the Constitution, it would have been clearly stated. I'm therefore of the view that Section 4 of the law number 7 is not inconsistent with Section 124.4 of the Constitution, unquote. The Court of Appeal in that case was of the view that the House of Assembly had power to make laws for the payment of remuneration of chairmen and councillors of local governments from the Consolidated Revenue Fund of the state, and that it is not inconsistent with the provisions of the law. Undoubtedly, the Supreme Court, by virtue of the provision of Section 235 of the Constitution, being the court of last resort, vis-a-vis the well-established doctrine of stare decisis, judicial precedent, this court and any court of law or tribunal must be bound by all the decisions of the Supreme Court. See the case of Odedo and PDP and others, citation captured. The point must be made that the doctrine of stare decisis is a sine qua non in the hierarchy or organogram of courts so as to ensure the certainty of the state of the law and its application. Hence, the subordinate courts are duty bound and without question must remain bound by the decisions of higher courts, especially the Supreme Court. It is, quote and unquote, gross insubordination and reckless judicial rascality for a lower court to refuse to follow or be bound by a decision on the point of law involved in the matter before him, which had already been settled by a higher court like the Supreme Court, which is the apex court of the land. See the case of Abubakar and Dauda and other citation captured, PDP and Oranezi and other citation captured. The learned jurist, a short GSC of blessed memory, in the case of Isaac Madubogo, Okonjo, and D. Mudiaga Oje, trying to make in the following words, I quote, in the hierarchy of courts in this country, as in all other free common law countries, one thing is clear, however learned the lower court considered itself to be, and however contemptuous of the decisions of the higher court, I hope it will never happen again, whereby the Court of Appeal in this country, or any lower court for that matter, would deliver to the extent of not considering the decision when those of this court of the law. This is what makes the law certain and prevents it from being an ass, unquote. It is in view of the above that this court now takes a different position from its earlier decision in line with the current decision of the Supreme Court in the above cited case of Charles Nwoke and Anambra State government and another supra, that this court strike down and nullifies the portion of the remuneration of certain public and political office holders, Kogi State, as amended, which fixes remuneration for the members of local government council to be drawn from the consolidated revenue fund of the state for being in contravention of the express provisions of the Constitution as amended in line with its powers under Section 315, subsection 3B of the Constitution. I equally nullify the local government political office holder salary structure as approved by Revenue Mobilization, Allocation, and Fiscal Commission Law 2009, which is being relied on by claimants in this case for being in contravention of the provisions of the Constitution. Accordingly, this court departs from its previous decisions earlier referred to in this judgment. Thus, I find that the claimant's claims based on the above nullified part of the law and the 2009 salary structure is bound to fail, notwithstanding that the court has found that they are entitled to be paid for January to October 2015 by virtue of the judgment of the Court of Appeal in appeal number CS/A/194/2015. In fact, any other ad-founded structure is equally bound to fail because an illegality cannot be the basis of a legal right. See the case of Amuda and Federal Republic of Nigeria citation capture, Nwosu and APP citation provided. The court will never shut its eyes to an apparent illegality. Thus, the subsequent acts of the House of Assembly, Kogi State, through every other means, directing payment of any sums to local government chairmen or councillors or any political office holders in the third tier of government in Kogi State, pursuant to the nullified portion of the law, based on the approved salary structure recommended by Revenue Mobilization and Fiscal Commission, will also be barred for illegality. Specifically, the letter of the House of Assembly dated 21st May 2013, which proposed to approve payment of salaries and other remuneration to leaders, deputy leaders, and councillors based on the 2009 remuneration of the Revenue Mobilization, Allocation, and Fiscal Commission is equally illegal because it was founded on an illegal 2009 recommendation of the Revenue Mobilization, Allocation, and Fiscal case have held unequivocally that the Revenue Mobilization, Allocation, and Fiscal Commission does not have the power to fix remuneration for the third tier of government under the Constitution and under it. What of the letter of the Kogi State House of Assembly dated 22nd May 2008, which communicated the House resolution on payment of severance allowances and other allowances to past local government political office holders to the Commissioner, Ministry of Local Government and Chieftaincy Affairs, which is also relied on by claimants. The said letter is at page 365 of the record of this court. I peruse the said letter and I find that it speaks for itself as it is the best evidence of its content. The said document is to the effect that the resolution relates to past local government political office holders from 1999 to date, the date being the date of the letter. The letter on the face of it was written on 22nd of May 2008. Then it means the resolution will only be for the benefit of those who served from 1999 to 22nd of May 2008 and not any other person. Nay, not even the claimants hearing. Claimants here served as councillors in the first dependent from 2013 to 2016 as in being on record. As such, they are not covered by the said resolution, consequently are discountenanced with the said letter. Again, as regards the claimant's claims to severance allowances, I would like to quote the dictum of Agim JCA, now GSC, in the case of Governor of Kogi and others versus Ahmed and other citation captured, where the court held inter alia does, and I quote, I must state here that claimants claim for payment of severance allowance because the tenure of the appointment has come to an end is as unfounded as is morally wrong. As I've held, their letters of appointment did not stipulate their entitlement to such payment. They did not produce any law or any document or instrument that entitles them to such payment. The fact that elected public office holders and political appointees are paid huge amounts of money as monthly salaries and other forms of allowances while in office is common knowledge in Nigeria and is not reasonably open to question. It is also common knowledge And many of them, after an office tenure of between 3 to 8 years, become stupendiously wealthy, exhibiting mind-blowing opulence and splendor. Yet these office holders insist on being paid severance allowance for holding such offices. Meanwhile, career civil servants who have served this country or their states or local governments all their life can hardly collect their pension and gratuities when retired. They are now being subjected to contributory pension schemes in which they contribute part of their monthly meager salaries that are always paid in arrears while in service to be able to earn pension and gratuity upon retirement. The political appointees and elected public office holders who do not work as long and as hard as career civil servants quickly get paid huge severance allowances upon leaving office, in addition to the huge wealth they acquired while holding such offices and without having been subjected to any contributory pension schemes. It is not morally right to pay an elected public officer or political appointee pension and gratuity or severance allowance for holding such an office for 3 to 8 years, as the case may be. It cannot be justified in the context of our present social realities. It amounts to gross social injustice. Provisions of Section 84, subsection 1 and 6 of the Constitution that provides that any person who has held the office of president or vice president shall be entitled to pension for life at a rate equivalent to the annual salary of the incumbent president or vice president if he was not removed from office by impeachment. Is not a moral law in the context of our governance experience since 1960. The same applies to Section 124, subsection 5 of the Constitution, which enables the House of Assembly to make a law providing for the grant of pension and gratuity to a governor or deputy governor of the state who was not removed from office by impeachment. This kind of provisions should not be contained in the constitution of a moral society, in which the primary objective of governance is the welfare and equal treatment of the people. The identifying character of a democratic constitution is that it vests the sovereignty of the country the people of Nigeria, from whom all authority of government is derived, and for whose welfare and security such authorities exercise. Such a constitution that promotes social justice and the existence of an egalitarian society should not contain features of feudalism, like the provision of pension and gratuity for holders of office of president, vice president, governor, and deputy governor of state, service of one's country, state, or any community in an elected or political office is an honor. The honor is derived from the selfless nature of the service. The purpose of public service is not to financially enrich the political office holder. In our present situation, where huge amounts of money are paid to the political office holders as salaries and unaccountable number of allowances while in office, which amounts of money make him very rich before the end of the tenure of such office. Any law that provides for the payment of pension and gratuity to such office holder after he leaves such office lacks moral justification, promotes social injustice, and cannot be democratic. The fact that the right is provided for in the Constitution, thereby made a constitutional right, does not make it morally right. It is an absurdity in the democratic constitution, unquote. Placing heavy reliance on the above succinct reasoning of Agim JCA, now GSC, I find that claimants in this case are not entitled to severance allowance in view of the facts stated herein before, coupled with the fact that there is no such provision in their letters of appointment. Before I end this judgment, let me comment on the way and manner counsel representing parties in this case cited authorities to this court, their respective final written addresses. The point needs to be emphasized that position of a judge is a delicate position. The work of a judicial officer is tedious, so any counsel who appreciate this fact will do everything possible to help lessen the burden on the court by citing authorities properly. It cannot be overemphasized that a counsel in citing a case must cite same with clarity, stating specifically the names of the parties, year of the report, law report, the volume and the part where necessary, and the page where the case can be found. Where the case is unreported, counsel must supply the court with a certified true copy of the judgment. See the cases of Chidoke and another First City Finance Company Limited, the case of Odedu and INEC citation captured. Then Claimant Counsel in paragraph 3.06 of his final written address cited the case thus: OUT versus ACB International Bank PLC and an order 2080 LAPELR, while addressing the court on the validity of the court's judgment, which has been set aside. First, let me say that I'm not aware that there is any law report as LAPELR. I think counsel proposed to cite from Law Pavilion Electronic Law Report, which is LPELR. This is the correct citation of the case in the said law report. O2 and ACB International Bank PLC and an order 2008 LPELR 2827, also reported as Ekanem Ekbo O2 and ACB International Bank PLC and an order. It is either learned counsel has not read the said authority but just lifted it somewhere, because if he did, he would have cited it properly, or that he just wants to mislead the court by giving a wrong citation. It is easier to assume the former. Also in paragraph 4.01 of his final written address, Leonard Claimant Counsel cited to this court a decision of my learned brother, Housetrop J, in an unreported suit number NICN/ABJ/189/2014. Honorable John Fashe and 18 others versus Honorable Adavurupu Saliu and 2 others, the judgment that was delivered on 6 June 2018. He even quoted from the said judgment. However, he did not place before the court a certified true copy of the judgment of my learned brother. Generally accepted practice is for counsel to supply the CTC of an unreported authority cited to the court. Besides, counsel doing such will also be assisting the case of his client. In the same vein, learned counsel on behalf of the second defendant, in paragraph 3.60 of his final address, cited the case thus: ZIRBGBE versus EYEKPIMI 2020 9 Nigerian Weekly Law Report, part 17929. He even quoted from the said law report without stating the page the said case can be found in the law report, or the specific page where the part quoted in his final written address can be found. Let me say that the correct citation of that case in the said volume and part of the law report where it's cited from is ZIREGBE, that is Idigbe and Eyekpimi. And it's a 2020 9 Nigerian Weekly Law Report, part 1729, page 327. The above trend notice and the final written address of parties should not be encouraged, because they tend to overburden the court by sending it on a wild goose chase, thereby wasting the precious and judicial time of the court at the stage of writing its judgment. Counsel, as ministers in the temple of justice, should learn to do better when citing cases to the court in order to forestall such situation as the one in this case. Now, for the avoidance of doubt and in view of all reasons to I declare an order as follows. 1. The provisions of remuneration of certain public and political office holders of this state as amended, which fixes remuneration for members of local government council to be drawn from consolidated revenue fund of the state, is struck down for being in contravention of the express provision of the Constitution. 2. Local government political office holders salary structure as approved by Revenue Mobilization, Allocation and Fiscal Commission 2009 is equally nullified for being in contravention of the provision of the Constitution. 3. The portion that relates to local government council in document title, Volume 1, Report of the Revised Remuneration Package for executive and judicial office holders at the federal, state, and local government levels, February 2007. Is also struck down for being inconsistent with the provision of the Constitution. Council. The document titled Volume 2, Report of the Revised Remuneration Package for Executive and Judicial Office Holders at the federal, state, and local government levels, February 2006-7, is also notified for being consistent with the provision of the Constitution. 5. Claimant's case is dismissed. Parties are to bear their respective costs. Judgment is accordingly entered.
As the court pleases.
My Lord, on behalf of the defendants, we want to especially appreciate my Lord for these well-delivered judgments, for the industry and hard work put into this. Lord, we are indeed grateful. We also want to apologize for how we cited authorities. We undertake to do better next time, Lord. We take the hint of the court. We're indeed very grateful, Lord.
Very well.
Thank you, Lord.
Call the next case, Lokoja. The next judgment.
and LKJ between 1. Honorable Thankford Olumoji, 2. Agala Sunday, 3. Honorable Nathaniel JP.
Court register.
Yes, my lord.
Are parties in court?
First claimant.
All the claimants are in court.
All the claimants are in court.
Yes, my lord.
Very well. Just a minute, I'm trying to see because I'm using my phone. Okay. Defendants absent.
Yes, my lord.
Appearances.
Please, my lord. I am here or not here for the claimants.
Any other appearance?
Yes, my lord. May it please the court. F.A. Oricha, legal officer. Number of appearances. Oricha. O-R-I-C-H-A. Number of appearances for the defendants, sir.
You said you are a legal officer.
Yes, sir. Legal officer.
Kogi State MOJ.
Yes, my lord.
For the defendants.
Yes, my lord.
Here's the judgment of the court.
Stop, please.
This action was commenced by a motion on notice filed on 6th of July 2020, brought pursuant to Order 2.1 of the rules of this court for the enforcement of fundamental human rights, which was subsequently converted to a general form of complaint by an order of court. Therein, claimants sought the following reliefs against the defendants. A, an order of this court declaring illegal, unlawful, null and void, constitutional, or the acts of the defendant that undermine the proprietary right of the claimants to their salary and other rights thereto relating to their movable property, to which the outstanding salaries and allowances as immediate past executive members and one immediate past elected councillor between the period of 2013 to 2016, yet unpaid, whether to violate, threaten to violate, and are likely to further violate the proprietary right to which financial rights of the claimants' salaries, allowances freely assess and collect and make use of their legally and worked for and duly entitled wages. Mr. Onoja, mute your phone. Have you muted yourself? 2, an order of this court declaring illegal arbitrary use of official powers unconstitutional, null and void, the act of the defendants arbitrarily, fully careless refusal to pay claimants their duly work for and legally earned salary, emolument,
on an illegal baseless shroud of shady tie to different political inclination or relationship of the claimants and dare to violate the fundamental rights of the claimants. C, another declaring illegal, void, null, and unknown to law, and lack of legal procedure and arbitrary use of official powers of the defendants without due regard to law and in violation of the claimant's fundamental rights to their movable property, which is their salary. I will skip the other reliefs. They are in all fours together. They are already captured in the judgment. So I will skip all that. It is the claimant's case that the first defendant was an ex-secretary to the third defendant, having been appointed by the chairman of the third defendant, and which appointment was confirmed by a House of Assembly, while the second defendant was an elected vice chairman of the third defendant, and the third claimant was appointed as supervisory councillor by the then chairman of the third defendant, in which capacity the claimants served separate, respectively. They maintain that the first defendant used the names of the claimants to retire monies in the guise of outstanding salaries and allowances in the acknowledged schedule of the third defendants, which sum they refused to pay claimants in violation of their fundamental human rights to means of livelihood. They went on that in their respective capacities, they served in their respective capacities, but was not removed from office by an order of the High Court sitting in Kotokarfi, which judgment was subsequently obtained at the Court of Appeal. The defendants to each, according to them, that pursuant to which they were reinstated to their positions, wherein they served till May 2016. That the defendants to each of the claimants during the period which they served and was not paid that the amount to which each of them are entitled to are 9,149,937, 9,339,813 naira, 6 kobo, 9,149,939 naira. At the expiration of their tenure, all the past executive, including claimants, were served with the schedule acknowledging the defendant's indebtedness of outstanding salaries as issued by the Account and Treasury Department of the third defendant in view of the Central Bank of Nigeria's bailout fund. The refusal of the defendants to pay off their outstanding salaries and allowances violates their proprietary rights to same. The defendant, according to the claimants, have severally asked the claimants to decamp from their party, that is PDP, to the APC before they will be paid their entitlement, which request the claimant have continued to decline. It is in view of this that they are asking the court to grant their reliefs. In response, the defendant filed their joint statement of defense and the subsequently amended same by an order of court. It is the averment of the defendants that the bailout fund was for the settlement of salaries of civil servants who were owed and not those who have been paid their salaries regularly between 2013 and 2016, and that the third defendant's allocation is paid through the accounts of the first defendant, but that the first defendant does not share any joint account or direct the management of the funds of the third defendant. Was also aware that the third defendant admit the ability for the payment of the arrears of salaries of claimant for the year 2015 due to the judgment of the Court of Appeal reinstating claimants who were employees of the third defendant between 2013 and May 2016. The defendant was equally part of the averment that the salaries of the claimants were paid in full, except for the outstanding 20% of their salaries and 40% of their salaries for the month of November and December 2014, but no notice of indebtedness was received or was served on the claimants acknowledging indebtedness, and as such deny ever acknowledging any indebtedness to the claimants. It was further averred that no undertaking was made that claimants will be paid any money as indebted salary, and the defendant had no reason to compel the claimant to decamp from a party of their choice, they ought the court to dismiss this case for lacking in merit. At the close of pleadings, parties by their counsel informed the court of their desire to adopt the argument on record procedure, and they did consent to the argument on record procedure pursuant to the 38 to 33 of the rules of this court. And by this special procedure, parties have dispensed with the need for oral hearing, and the case is to be tried on record. The claimant first filed their final addresses, followed by the defendants. I have reduced the content and the arguments in support into the body of the judgment. I'm now going straight to the decision of the court. After an in-depth perusal of the processes filed by parties in this case, the documents relied on, and final written addresses of parties, I am of the humble view that the issues that will best determine this case are: one, whether the documents relied on by claimants are competent and admissible, and two, whether claimants have proven their case to be entitled to the relief sought. On issue one, it is the submission of learned counsel on behalf of the defendants in paragraph 3.5 of his final written address, that document front-loaded by claimants that is titled, quote, Guidelines for Honorable Chairman of Local Governments of Kogi State Ministry for Local Government and Chieftaincy Affairs of 10th May 2013, though pleaded but not front-loaded, is incompetent and cannot be relied upon by this court. The law is settled that what guides the court as to what transpired before the court is the record of the court. I've looked through the record of this court and found that the said document was not only pleaded in the statement of facts of the claimant, but also front-loaded, contrary to the submission of learned counsel for the defendants. It is at pages 160 to 165 of the record of court. Be that as it may, it is the contention of the defendants that the document pleaded in paragraph 27 and 35 are public documents that ought to be certified. Stated earlier in this judgment, parties had consented to the adoption of the argument on record procedure of this court. It is needful for me to first say here that by the nature of those documents, they are truly public documents, and which admissible copy is either the original or a certified copy of it, photocopy. However, the point needs to be made that the law is settled that a party who has consented to a particular procedure adopted by court cannot turn around to complain on same that it worked injustice against him. See the case of Ahame Fule and Imperial Medical Center, citation captured. Order 38 to 33, one of the rules of this court, provides thus, and I quote, in any proceeding before the court, parties may by consent at the close of pleadings agree to a trial record where they rely on the documents and exhibit front-loaded, and thereby dispense with the need for oral testimony and or cross-examination, unquote. In this case, voluntary consent of parties to the argument on record procedures presupposes that they have agreed that this case is to be tried on the basis of pleadings and documents front-loaded by parties on record. It is notorious that usually it is photocopy of documents that is front-loaded and not original. The point must also be made that the essence of certification of photocopy of public document is for authentication. In the case of Kazim and the state citation captured, ECHO GSC now retired held those on certification of public documents, and I quote, now what really is the essence of the demand for a certified true copy of a public document? I think, and in agreement with Vadekaya GSC, in Goodwill and Trust Investment Limited and Wheat and Bush Limited, the essence of demanding for a certified true copy of the public document is the assurance of the authenticity of the document vis-a-vis the original. See also the case of Tabik Investment Limited and Guaranteed Trust Bank PLC, citation captured. The case of Alamesi and Federal Republic of Nigeria, citation captured. The failure to certify the document front-loaded will only be fatal if the authenticity of the document is in doubt or that the defendants deny the existence of those documents. Besides, by the provisions of Article 15, Rule 3A and B of the Rules of this Court, 2017, Where a defendant or respondent is served with a schedule of documents or any recording by an electronic device to be relied on at the trial by the claimant, in compliance with other 3 rules, 9 and 10 of the rules of this court, the defendant shall file and serve along with his defense a schedule that indicates schedule of documents not objected to. And another one should be a schedule of documents objected to. Order 15, Rule 4 of the rules provides further that any document or recording by an electronic device containing the schedule which is not objected to by the defendant shall be deemed admitted except the court otherwise directs. The defendants did not file any such schedule objecting to any document in this case. They are thus deemed to have admitted those documents and cannot at this stage be raising the question of admissibility of those documents, especially where the procedure adopted by consent of parties in this case is a special one. It is in the light of these and all the foregoing that I discountenance the objection of learned defense counsel to those documents. Issue 1 is thus resolved in favor of the claimants. Now to issue 2. Learned counsel on behalf of the claimant read issue 3. In the final written address, I've submitted that the relationship between claimants and the defendant is that of employment for salaries and allowances. In fact, he seems to have proceeded in paragraph 2.2 of his final written address that the relationship of the claimant with the defendant is one with statutory flavor regarding emoluments, salaries, wages, and other financial benefits. Learned counsel did not, however, refer to any statute which imbued the relationship between parties with statutory flavor. Be thus as it may, I do not agree with the submission that the relationship between claimants and defendants is one with statutory flavor, and I'll proceed to explain why. The law is settled that there are basically 3 types of employment relationship, namely purely master-servant, employment with statutory flavor, and employment held at the pleasure of the employer. So the case of Oak Pension Limited and the online income citation captured. Although Section 7 of the Constitution of the Federal Republic of Nigeria 1999 as amended provides for the establishment of a democratically elected local government council, this does not clothe the employment relationship between the claimants and the defendants with statutory flavor. In the instant case, recourse must be had to the respective letters of employment or appointment of claimants in order to determine the kind of employment the claimants held. The first claimant was a former secretary to Ola Maboro local government, and his letter of appointment is at page 151 of the record, dated 17 May 2013. He is clearly a political appointee from the content of the letter. He was appointed by the local government council. In the case of PDP and Idigbe, the court held that a political appointee or political office holder's appointment is at the pleasure of the person who appointed him and does not have any statutory flavor. Therefore, it is clear that first claimant's appointment is at the pleasure of his appointer and not one with statutory flavor. The second claimant, by virtue of the pleadings and the document at page 153, was elected vice chairman. This makes him an elected political office holder and nothing more, and not an employee whose employment is imbued with statutory flavor. In the same vein, the third claimant was appointed a supervisory councillor, and his letter of appointment, which is dated 12 June 2013, is on page 152 of the record. The letter clearly states that his appointment is at the pleasure of the chairman of local government council. There is therefore no doubt that his appointment is one held at the pleasure of the chairman of the local government. See the case of Oni and others versus Governor of Ekiti State, citation provided. Therefore, it cannot be said that the relationship of claimants with the defendant is one with statutory flavor, as learned counsel on behalf of the claimants will want this court to believe by paragraph 2.2 of his final written address. I so find and hold. Albeit, the point needs to be made that this action is declaratory in nature. I say so in view of the fact that claimants bid relieves in their general form of complaint 6 orders from this court declaring the action of the defendant as illegal, unconstitutional, null and void. C relieves in the general form of complaint. The law is settled beyond arguments that declaratory actions are exceptions to the general rule of admission as provided in sections 20 and 21 of the Evidence Act 2011. Such will not succeed on an admission of the defendant. See the case of Alasan and another and Ishaku. Citation capture, Lukonko and Lukonko. Citation provided. Thus, claimants in declaratory actions must always rely on the strength of their own case and not on the weakness of the defendants. The claimants herein have contended a failure to pay them their entitlement, being their outstanding salaries and allowances as immediate past executive members and one immediate past elected councillor between period of 2013 to 2016 is a breach of their fundamental rights, contrary to sections 33, 34, 35, 43, and 44, 1 and 2, as well as 254C of the Constitution, and Articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Rights Ratification Enforcement Act, Cap 10, Laws of Federation 1990. The right of litigants to approach the court to enforce their fundamental rights is conferred by Section 46(1) of the Constitution. Such actions are usually complaints against tortious acts of the defendants. Thus, in order for litigants to succeed in an action aimed towards the enforcement of their fundamental rights, they must be able to show how the said rights have been breached or infringed upon by the defendants. The settled position of the law in cases of allegation of violation of fundamental rights is that a mere allegation is not sufficient to constitute proof of infringement or infraction on the rights of the party alleging the specific facts of infringement must be proved in substantial details. See the cases of Abuja Electricity Distribution Company, PLC, and others versus Akaliro and other citation captured, Oando PLC versus Pharmatic Biogas West Africa Limited, and another citation captured. The court must not give to speculation, conjecture, or logical deductions. The party alleging has a duty to furnish in substantial details the fact of the rights and infringement of the said rights before the court. Claimants in support of their case that the defendants have willfully and illegally refused to pay them their outstanding salaries have relied on the document titled Guidelines for Honorable Chairman of Local Government of Kogi State Ministry for Local Government and Chieftaincy Affairs, dated 10th May 2013, hereafter referred to as guidelines, which was pleaded in paragraph 13 of the pleadings. Is also at pages 160 to 165 as stated supra. I perused the said document and I find that it specifically states that the remuneration of local government executives ranging from chairman to supervisor, secretary, leader, deputy leader, councillors, and special assistant shall be as approved by Kogi State House of Assembly. See page 163 of the record. Claimants herein have not placed before this court any document showing the approved remuneration of any of the above listed categories of local government executives by the Kogi State House of Assembly, as they refer to, although they relied on document titled Olama Borough Local Government Outstanding Salaries and Allowances of Immediate Past Elected Councillors, 2013, and Olama Borough Local Government Outstanding Salaries and Allowances of Immediate Past Executive Members, 2013 to 2016. Both documents are at pages 154 to 159 of the record. I peruse the said documents and I find the names of the claimants on the second document titled Olama Borough Local Government Outstanding Salaries and Allowances of Immediate Past Executive Members, 2013 to 2016, specifically at pages 158 to 159, which according to them was a document issued by the Account and Treasury Department of the third defendant, acknowledging indebtedness to the officers who served between 2013 and 2016. However, defendants in this case by original statement of defense and also in the amended joint statement of defense have vehemently denied that not acknowledging any indebtedness to the claimants. It is tried that by the state of pleadings, burden of proof is usually on the party asserting the positive or the affirmative. See the case of Fodili and Onejeme, citation captured, Obe and MTN Nigeria Communications Limited, citation captured. the burden of proving that the documents emanated from the account and treasury department of the third defendant and in acknowledgement of debt owed claimant is on the claimants who are asserting same. There is nothing on the said document to show that the said documents emanated from the account and treasury department of the third defendant as alleged by claimants in their pleadings. In fact, the said documents with particular emphasis on the one titled Olama Borough Local Government Outstanding Salaries and Allowances of Immediate Past Executive Members 2013 to 2016, which specifically relates to claimants, were not signed to even show its origin. The essence of signature on the document cannot be overemphasized, and that is to show authorship and genuineness of the documents. See the case of Ashaka Sam PLC versus AM Investment Limited, citation captured. The law is settled that an unsigned document which is clearly of unexplained and dubious origin cannot be relied upon by the court in resolving crucial issue in dispute. In fact, an unsigned document which does not have a proven origin is incapable of conferring legal benefits. See the case of O'Rourke and Etta, citation captured. The case of Abga versus Amakura, citation captured. Defendants can only be bound by the said document if the document has been shown to have been authored by them. In this case, there is no proof that the said document emanated from the third defendant as alleged by the claimants. Therefore, this court is weary of relying on same. I am mindful of the submission made by learned counsel to the claimant severally in his final written address that the defendants admitted the indebtedness as captured in the schedule of indebtedness by their joint statement of defense. In fact, it was submitted categorically by learned counsel to the claimants, be it paragraph 7.4 of the final written address, that the indebtedness in the schedule was admitted by the defendants. Column as it reflects specifically the names of the claimants, be it paragraph 6 to 11 of the journal in paragraph 7.21 of his written address, wherein he submitted that the common ground from the pleadings of both parties is that the defendants are owing claimants 20% salaries in December 2013, 40% salary in October, November, and December 2014, full salary from January 2015 to October 2015, leave or recess allowance, 50% January salary 2016, and full salary for March and April 2016, as well as leave, furniture, and severance allowances. The schedule showing indebtedness contains several columns covering several claims for percentage of arrears of salaries, leave allowance, furniture allowance, and several severance allowance as it relates to those captured there, including claimants. I have perused the amended joint statement of defense of the defendants, which is the extant process of the defendants. Let me say that it is not true that the defendants admitted column by column the indebtedness as captured in the schedule, showing indebtedness to claimants. In fact, from those paragraphs of the amended joint statement of defense, what can be deduced is that the defendants admitted liability for payment of 2015 salaries due to the judgment of the Court of Appeal, reinstating claimants to office. They, however, maintained that claimants' salaries were paid in full in 2013, except for 20% in the month of December, and also paid in full in the year 2014, except for 40% for the month of November and December 2014. They equally denied ever acknowledging indebtedness to claimants. I do not therefore see how the averments of the defendants above in the amended joint statement of defense can be interpreted to mean that the defendant admitted and acknowledged the indebtedness captured in the schedule, showing the indebtedness column by column as learned claimant counsel will want this court to believe by its final written address. This is because there are other columns in the schedule which relates to payment of salaries for other periods and several other allowances which were not admitted by the defendants in the amended statement of defense. The pleadings of the defendant is clear to the effect that the only part they admitted that claimants have not been paid 2015 salaries pursuant to Court of Appeal judgment, and also 20% for the month of December 2013, and 40% for the month of November and December 2014. I do not lose sight of the submission of learned claimant counsel in paragraph 7.13 that the court should, in line with order 34, will follow the rules of this court, enter judgment on the part admitted. Let me say that the claimants in their pleadings did not specifically plead what their salaries in 2015 would be. Neither did they plead what 20% of their December 2013 salary would be. They equally did not plead specifically what 40% of their November and December 2014 salary is, for the court to be able to clearly enter judgment on this admitted portion. It is not the duty of this court to do cloistered justice, to start calculating what those admitted salaries and percentages will be, without specific averment as to how much percentage will be. Besides, it must also be noted that notwithstanding the above admission of defendant as to 2015 salaries pursuant to the judgment of the court, 20% of December salary and 40% of November and December 2014 salaries, claimants still have the burden to prove their entitlements to the sum of 27,639,687 naira 6 kobo claimed, as the sum claimed being special damages, which will not succeed merely on an admission. See the case of Capital Hotels PLC and Abdullahi citation captured, Aliu and Bulaki citation provided. Emphatically, the Apex Court held in the case of NNPC versus Clifco, Nigeria Limited Supra, does, and I quote, a claim for special damages will not succeed simply because there is admission of the claim. Special damages are never inferred from the nature of the act complained of. They do not follow in the ordinary course, as is the case with general damages. They are exceptional and so must be claimed specifically and proved strictly. Unquote. In the said case of NNPC and Clifco, Nigeria Limited Supra, Rose Bibles, JSC now retired, emphatically held, and I quote, evidence ought to be laid before an award for special damages is granted. To succeed in a claim for special damages, it must be claimed specially and proved strictly. The fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof with compelling evidence. Special damages are exceptional in character, and so there are no room for inference by the court. It is unreasonable to consider a claim for special damages succeeds on compelling evidence to justify it, and not on the sums claim appearing reasonable to the court, unquote. In view of the abundant judicial authorities cited, I am of the unwavering view that notwithstanding the admission in the amended joint statement of defense, claimants still have the burden to prove their entitlement to the sum of 27,639,687 naira 6 kobo claim as outstanding salaries and allowances, which is special damages. Specifically, the claimants are claiming the above sum, which purportedly represent the outstanding salaries and allowances of their allowances. In paragraph 21 of the statement of claim or statement of fact, it was averred that the first claimant is being owed the sum of 9,149,937 naira, while the outstanding salaries and allowances of the second claimant is put at 9,339,813 naira 6 kobo, and that of the third claimant is put at 9,149,937 naira. The law is very clear that monetary claims are in the realm of special damages that I've stated earlier. The Apex Court per Mohammed GSC, in the case of Union Bank and Nwako, held does, and I quote, it is indeed right that a claim for special damages must not only be specifically pleaded item by item by corresponding monetary value of the claim item. The item as particularized must further be proved by credible evidence for the court to grant the claim. Where special damages have not been specifically pleaded and proven, same shall not be granted. The claimants did not specifically plead with distinct particulars item by item named as outstanding salaries and allowances of each of the claimants. I am mindful of the averments of claimant by paragraph 15 of the reply to the statement of defense that 20% of December 2013 salary deficit admitted to be owed by claimant is captured in column 5 of the schedule of outstanding salaries and allowances for past executive members. The averment of claimants in paragraphs 11 to 17 of the reply to the defense will not suffice as specifically pleading how they came by the quantum of the sum claimed for each of the claimants with distinct particularity. It should have gone further to plead specifically each of those sums captured in the said schedule of the indebtedness in respect of each claimant, referring to different columns of the said schedule of the indebtedness in the averments in paragraphs 11 to 17 of the statement of their reply to the statement of defense. Their failure to do so in their pleadings has disentitled them from making such claim before this court. Also, it must be borne in mind that pleading a fact is not synonymous with evidence required to prove that fact, as pleadings do not constitute evidence, but are to be proved by evidence. See the case of Sokoto and INEC citation captured. Claimants merely pleaded by paragraph 11 of reply to monthly salaries of 266,399 naira, 291,460 naira, 266,399 naira. Claimants did not place before the court any documentary evidence, whether by way of bank account statement or pay slip, in support of the sum averred as monthly salary of each of the claimants. They equally failed to show the quantum they have received and the sums remaining as outstanding in line with the sums captured in the schedule of indebtedness to claimants. In fact, they merely averred in paragraph 11 to their reply that details of the vouchers of salaries paid and signed for are in the custody of the third defendant. They did not give the defendant notice to produce same. Learned counsel on behalf of the claimant proceeded by paragraph 5.13 and 7.21 of the final address that defendants are withholding the sensitive evidence of the said vouchers. Section 167, paragraph D of the Evidence Act as it relates to the presumption of withholding of evidence will only apply against whom it is thought that it should operate where that party has in fact withheld particular piece of evidence in issue, and the document is essential to clarify ambiguities or the dispute. See the case of Idigbe and Idigbe citation captured. It is worthy of note that the mere failure of not producing evidence will not necessarily amount to withholding such evidence. The two are not synonymous. In the case of Idigbe and the state, the Apex Court held that before the presumption can exist, it must have been shown that such evidence existed, and it was the party that withheld it. The court would have to be satisfied in each case whether the circumstance justifies the finding that the evidence has been withheld, and in which case the said evidence must be shown to have been in existence or in possession of the defendant and also was deliberately withheld. Defendant, in this case, sought leave of court to amend their processes, and it was granted. They filed plain copies as ordered by the court on the 25th of May, 2022. I perused the said amended process along with its accompanying processes at pages 324 to 342 of the record, and I find that payment vouchers were annexed to it as part of documents relied on, which in my view is in line with the leave granted the defendants to file additional documents. I perused the said vouchers and I find that they are payment vouchers of the first claimant for the months of June, July, August, September, October, November 2013, January, March, April, June, July, August, and September 2014. It is clear from the said vouchers that the first claimant monthly salary is 266,399 naira, as averred in the reply to the statement of defense. Defendants, by paragraph 9 of the joint statement of defense, averred that the vouchers are evidence of payment of claimant's salary for years 2013 and 2014, as well as January to May 2016. It is my respectful view, therefore, That claimants in this case bear the burden to prove non-payment of the sums captured in the document by producing their respective statement of account, showing that salaries were not paid into their respective account during the period in contention. Most especially where in civil case, such as this instance, the burden of proof lies on the person who will fail. It is worthy of note that the said schedule of indebtedness to claimants captured the amount number of each of the claimants, the account number of each of the claimants. However, statement of each of the account referred to has not been placed before the court to show truly that the sum claimed were still outstanding, having not been paid into their account. Said document shows that some percentage of their salaries were still outstanding, as claimants have not placed any evidence before the court to show how much they have received in line with the schedule, as I've stated earlier. The schedule showing indebtedness to claimant relied on in support of the sum claim will not relieve the claimants of the burden to specifically plead how they came by the quantum, as I've stated severally in this judgment. It will equally not relieve the claimants of the burden to put credible evidence in support of same. It is their duty. It is the duty of the party who claims special damages to place before the court sufficient material to guide the court in its decision to award such damages. The failure of the claimants to specifically plead and prove their entitlement to the sum claim is very fatal to their case. It is only when claimants have successfully proven their entitlements to the sum claim that they can succeed in proving that the failure of the defendants to pay them is a breach of their fundamental rights, means of livelihood. In this case, they have failed to prove their entitlement. Let me also point out that claimants who are claiming to be entitled to and have a right to own movable and immovable properties by way of salaries and allowances by virtue of the provisions of sections 33, 34, 43, and 44 of the Constitution, as well as the African Charter on Human and People's Rights Act, which according to them cannot be denied them, did not place before this court any instrument or documents that vest such immovable properties in them, in the sense that they have failed to place before the court any instrument or document that provides that certain amount be paid to them as salaries and allowances in their capacities as secretary, vice chairman, and supervisory councillor in the third defendant, respectively. There's no provision for how much claimants are entitled to as salaries and allowances in both their letters of appointment and the certificate of return, respectively, placed before the court. Thus, those documents are silent on their monetary entitlements. There's equally no document which shows clearly the allowances claimants are entitled to be paid by virtue of the positions they held in the third defendant. Put differently, they have not placed before the court any document which support the payment of allowances to them in their respective capacity, apart from the guidelines and schedule showing indebtedness to them, which document this court has held to be insufficient to prove the indebtedness of the defendant to them. Guidelines as reason supra clearly provides that remuneration to which local government executive, which includes claimants, shall be entitled to, shall be as approved by the House of Assembly, Kogi State. In fact, claimants by paragraph 6 of their reply to the defense aver that the specific details of amount of salaries and allowances approved by Kogi State House of Assembly to be paid to claimants are forwarded to the Account and Treasury Department of the third defendant, who prepares vouchers based on these specific salaries and allowances that are to be paid to them through their same department through the account department. Claimant did not place the said instrument, which according to them contains the specific details of their salaries and allowances as approved by Kogi State House of Assembly, and forwarded to the Treasury and Account Department of the third defendant before the court. They equally did not give the defendant notice to produce this document. The claimants in this case should have pleaded an instrument of document showing the approved salaries and other remuneration of claimants by the House of Assembly of Kogi State in line with the content of the guideline, but they did not place any before this court. For the claimants to succeed, they must be able to show that a particular instrument or document entitles them to certain amount of salaries and certain allowances as approved by the House of Assembly. The point must be made that this court, just like every other superior court of record, by virtue of the provision of section 122(2)(a) of the Evidence Act 2011, shall take judicial notice of all laws and enactment and any subsidiary legislation. It is in exercise of this power that this court takes judicial notice of the provision of the remuneration of certain public and political office holders law of Kogi State 1999 as amended by the First Amendment 2000 and the Second Amendment 2006, hereafter referred to as remuneration of certain political and public and political office holders law as amended, which is a law made by Kogi State House of Assembly, which proposed to fix and approve the remuneration of public and political office holders in the state. The position of the law is that courts is empowered to raise an issue so motu and take a decision on it without the need to call parties to address it where parties in the argument fail to take into consideration the statute which has bearing on the matter or when it relates to the court's jurisdiction. See the case of Jai Simi and Darlington, citation capture, Enayo and Ngere, citation provided. Parties in this case have failed to take into consideration or ignore the provisions of the law under which claimant as Secretary, Local Government Council, Vice Chairman and Supervisory Councillors respectively are entitled to be paid, which law should have been the fulcrum of the claimant's claim to entitlement to salaries and allowances in the first place. Claimant were merely relying on the guidelines and the schedule, showing indebtedness to claimant which documents are insufficient to prove their indebtedness. It is in the light of the above that this court take judicial notice of the remuneration of certain political office holders law as amended. The said law makes provision for remuneration of local government executive among other public office holders in Kogi State. The third schedule thereof contains a table of fringe benefits, including severance allowances payable to local government executives under the law. By the provision of the remuneration of certain public and political office holders law as amended, salaries and other remuneration of chairman, vice chairman, supervisor, local government, secretary to local government, special assistant to local government council shall be charged upon the consolidated revenue fund of Kogi State. See section 3 of that law. The effect of this is that local government appointees are to be paid salaries and emolument under this law, and that the respective salaries and emolument prescribed under the said law shall be charged upon the consolidated revenue fund of Kogi State. The position or offices of secretary to local government, vice chairman held by the first and second claimants as specifically captured in the law as positions which remuneration shall be charged upon the consolidated revenue fund of the state. See section 1(4) of the remuneration of certain public and political office holders law as amended. The position of a supervisory councillor held by the third claimant was aptly captured as part of the positions to which fringe benefits, which include severance, constituency allowance, and furniture allowances, were provided for. See the provision of the third schedule of the remuneration of certain public and political office holders law. In fact, those three positions held by claimants respectively are clearly captured in the table in Schedule 3 to the remuneration to that law. The Supreme Court in the case of Lokoja and Anambra State government and another citation captured have held while considering a similar law in Anambra State that any expenditure that is to be charged upon the consolidated revenue fund by the Constitution shall be as stipulated by section 124, subsection 4 of the Constitution of Nigeria as amended, and which section did not include the third tier of government. The consequence of the above is that inclusion of chairman of local government, vice chairman, secretary to local government, supervisors, special advisors or PA to the chairman, leader of the local government legislative council, deputy leader, and councillors by the Anambra State Law number 7, 2001, in the list of political office holders or public officers whose salaries shall be fixed by the Revenue Mobilization, Allocation and Fiscal Commission and charged upon the Consolidated Revenue Fund of Anambra State is against the express provision of section 124, subsection 4 of the 1999 Constitution as amended. The court went further that Anambra State Public Officers Law number 7 of 2001, which purported to fix salaries and emolument of those officers mentioned herein before, charged upon the Consolidated Revenue Fund of the state, was enacted or traversed the Anambra State House of Assembly and is as a result inconsistent with the provisions of the Constitution. It is in the light of this that this court, in an unreported suit number NICN LKJ/07/2020, the case of Honorable Bello S. Ajiga and 9 others, Associated Local Government Council Learned Counsel. Learned Counsel.
Yes, my lord.
Yes, copies of the judgment will be forwarded to you in Lokoja.
As copies.
I hope you heard the last portion of the
No,
judgment.
no, my lord. We did not hear the last portion.
This is technology. Which part was the last part you heard, please? So I can go over that last one, the portion. Okay, in view of all reasons to press.
Reference was made to one Anambra.
Anambra decision.
Yes, my lord.
Yes. And I went on to state that by the position of the Court of Appeal, Supreme Court in that decision, let me go about that then, if that was what you just heard. The Supreme Court in the case of Lokoja and Anambra State and government and another, held while considering a similar law in Anambra State, that any expenditure that is to be charged upon the Consolidated Revenue Fund by the Constitution shall be as stipulated by Section 124(4) of the Constitution of Nigeria, and which section did not include the third tier of government. The consequence of the above is that the inclusion of the chairman of local government, vice chairman, secretary to local government, supervisors, special advisors, or PA to the chairman, leader of local government legislative council, deputy leader, and councillors by the Anambra State Law number 7, 2001, in the list of the political office holders or public officers whose salaries shall be fixed by the Revenue Mobilization and Allocation and Fiscal Commission charged upon the Consolidated Revenue Fund of Anambra State is against the express provision of Section 124(4) of the Constitution. Can you hear me, please?
We can hear you, my lord. We can hear you.
Very well. It is in the light of this that this court, in an unreported suit number NICN/LKJ/07/2020, the case of Honorable Bello S. Ajiga and 9 others versus Okene Local Government Council and another. The judgment that was delivered this morning on which is 14th of March 2023, struck down the provisions of remuneration of certain public and political office holders law as amended, which purports to fix salaries and remuneration for claimants for chairman, vice chairman, secretary, supervisor, special assistant to local government chairman, which is to be charged upon the Consolidated Revenue Fund of Kogi State as illegal and unconstitutional. The effect of this is that the salaries of claimants who were ex-secretary to local government, vice chairman, and supervisory councillors respectively, which is charged upon the Consolidated Revenue Fund of Kogi State, is illegal. In view of all reasons supra, it is clear that the claims of the claimants, apart from the fact that same cannot stand for failure to specifically plea and for lack of proof, will equally fail because the portion of the law under which the claimants are entitled to be paid has also been struck down for being inconsistent with the provision of the 1999 Constitution. The proper order to make here is that, the proper order to be made in this case is one of dismissal, as the case of the claimant is bound to fail. Accordingly, claimant's case is hereby dismissed. Parties are to bear their respective costs. Judgment is accordingly entered.
That's God pleases. I'm most grateful for the well-considered judgment, my lord.
So like I said, I will send copies of the judgment to you.
That's God pleases.
Lokoja.
We're grateful, sir.
Very well, I rise.